So in this, we're going to look at the independence of the judiciary in Uganda. So what is the independence of the judiciary in Uganda? Yes, you realize that there was a system of separation of powers where three arms of government were created. That is the legislature, which role has to make the law, the judiciary interpreting the law, and then the executive to implement the law. So in Uganda, we have a full arm or the full organ of the judiciary that is clearly seen in chapter 8 of the Constitution, which judiciary is headed by the Chief Justice. So while the judiciary's role is to interpret the law, meaning that it has to give what we call natural justice to the people. If it is to give natural justice to the people, it was thought wise that it should be independent in its activities. So independence of the judiciary has been clearly established and interpreted under Article 128 of the Constitution, and various cases have come in. For example, the case of Masuru Musene versus Attorney General, all explaining the concept of independence of the judiciary. So the judiciary should be independent in its activities. So let us see what are the components or the tenets or the pillars of independence of judiciary in Uganda. So the pillars of the independence of judiciary in Uganda can be seen in Article 128. So the first pillar is that the judiciary shall not be, or no organ should interfere, or state agency should interfere in the roles or in the duties of the judiciary. There are various organs, there are various states. For example, we see the army, military, police, among others. Those agencies should not interfere in the duties of the judiciary. Judiciary should be independent. Why? No, or one way is that no state agency organ should interfere in the roles of the judiciary in order for there to be judicial independence. So that is the first pillar. The second pillar to ensure that there is independence of the judiciary is that all state agencies should assist the judiciary whenever need be. So realize that there are certain situations where now to say maybe someone committed an offense, we have to get assistance from certain experts, which can be government experts. So whenever judiciary needs assistance from any state agency, police, military, among others, that a state agency should assist. Then the other one is that the judiciary should be self-accounting for it to be independent. That is the third pillar. What does this mean? Judiciary should pay its money or should get its money direct from the consolidated fund, not into the issues of appropriation by parliament, because they know or they knew that if the parliament appropriates or decides what money should be given to the judiciary, the parliament can control the judiciary. So it's better, they say, that the judiciary should be self-accounting. All its money should be gotten from the consolidated fund. That is the pillar number 4. Number 3. Then pillar number 4 is that judiciary or judicial officers or judicial immunity. What does this mean? While a judicial officer is entertaining a matter, judicial officer does not only mean a judge, a clerk, among others. Any person who is explained to be a judicial officer, while entertaining or hearing or handling a matter, he should not be liable to any civil or criminal liability arising out of that matter. If a judicial officer is seated in the chair as a judge and does not do what he had to do, you cannot sue him in courts of law for failing to do what he had to do. Why? Because of judicial independence, judicial officers are given that judicial immunity. So there are various other aspects that comprise the aspect of the system of independence of the judiciary. So briefly, you have to look at Article 128 of the Constitution. Thank you very much.